As Miriam said, my name is Stacey Harper. I'm from the University of Glasgow's Data Protection and FOI office. I am here today to give you a very brief sort of whirlwind overview of the Data Protection Act. It's going to be pretty high level. It'll probably be kind of fast, so there will be time for questions at the end. And as Miriam said, you'll also get the slides afterwards. So to get started, the Data Protection Act 1998 is a piece of legislation that is basically about sort of balancing individuals' needs and rights to privacy for their own information and the needs and rights of an organization to use that information. So this legislation basically lays out what you should be doing to create that balance. The foundation of the legislation are these 8 data protection principles. Everything that you're doing with personal data must be done in line with these principles. If there is ever a breach of any one of these principles, if you ever fall down on any of these principles, that's the breach, and it is a potentially finable offense. So I will go through all of the principles individually. They are all equally important. They're not ranked in any way just because they're numbered, just to make that clear. So the first principle is that personal data must be fairly and lawfully processed. What that means in effect is that people need to know that you're using their information, which is fair enough if you think about it from your own perspective. They need to be aware that you've got their info. They need to know why you have it, what you're planning on doing with it, if you're going to be sharing it with anybody, just the basics, so they have an understanding and expectation as to what's going on with their info. That's the fairly side of that phrase. Lawfully means you need to meet certain obligations in order to use their data, and your use of data cannot circumvent any other legislation out there, which should be pretty straightforward. Second principle, personal data must be processed for limited purposes. So that means whatever your stated reasons for using and collecting that personal data, whatever you've effectively told people you're going to be doing with their information, that's all you get to do with it. You can't use extra info for just in case reasons or because you think it might be useful or helpful. You have to stick to your limited purposes for processing. The third principle is that personal data must be adequate, relevant, and not excessive. That means, in a nutshell, you can't have extra info just in case. You need to make sure that you have the right amount of info and the right type of info for the task at hand. The fourth principle, personal data must be accurate. That's very straightforward. You need to make sure that the information you hold on people is accurate and up to date. And if it's not, if they let you know that the info that you have is incorrect or out of date, you have to make changes to that information that you hold. The fifth principle is that personal data must not be kept for longer than is necessary. That means that you need to have a statable and justifiable reason for keeping personal data for however long you're keeping it. Maybe there's a law that says you must keep that personal data for X number of years. Maybe, and this is maybe more likely for you guys, you have a funder requirement that says you need to be keeping your research data for 10 years or whatever the case may be. Maybe you just have a business need in your research lab or in your organization that says we need access to this information for X number of years so that we can continually refer to it. Whatever the case is, you have to have that argument, and that's where records management comes into play, and I'll talk about that a little bit later, but that's the idea of basically stating your retention for information and organizing your retention. Sixth principle, personal data must be processed in line with your rights. Very briefly, you have a number of rights under this legislation. As an individual, you have the right of access to your information, so you can ask to see what an organization holds. You have the right to have incorrect information changed or corrected. You have the right to object to processing. You have a few other rights, but whatever we do with personal data as an organization or as an individual, we have to do it in such a way that people can exercise their rights. Seventh principle is very straightforward. Personal data must be kept securely, and we need to show that we have adequate precautions and safeguards in place to ensure the security of personal data. So if something does go wrong, if information is lost or destroyed or stolen, you can point to your safeguards and say, well, we had these security precautions in place and we tried to keep things safe. And then the last principle, personal data must not be transferred out with the EEA without adequate precautions. So if you are doing any data sharing, particularly outside the EEA, but in reality, if you're doing any data sharing outside your organization at all, you want to ensure that you've got a data sharing agreement in place. I'll talk a little bit more about that later, but that would be your adequate precaution. A data sharing agreement, data transfer agreement, data processing agreement, they're all different names for basically the same thing. And you need one if you're sharing data. So personal data is defined in the legislation. I'm going to go through the definition here sort of point by point because there's a few different bits that we want to pull out. Personal data is data which relates to a living individual who can be identified A, from those data, or B, from those data and other information which is in the possession of or likely to come into the possession of the data controller. So to go back to that very first bit, personal data is only information about living individuals. So the deceased are not covered by this legislation. If you're doing any research, maybe in forensic medicine or something like that, any research with the deceased, this is not necessarily your concern, this legislation. You will need to make sure that there's no other living people who get sort of drawn into your research. But if you're only working with data about the deceased, you can just ignore me now, basically. The first point, A, data which relates to an individual who can be identified from those data. So if you have a data set and it directly aids in identification of a person, then that data set is personal data. So if you've got date of birth and you have got images and you've got educational background and educational history, employment history, all that kind of stuff directly pinpoints and IDs one person. That's their personal data. That's fairly straightforward. Point B is a little more complex. That is that personal data is data which relates to an individual who can be identified from the data that you hold and from any other data which may be in the possession of the data controller or your organization, or may likely come into the possession of that organization. So what that means is you basically have a data set that on its own doesn't really look like it identifies anybody, but there's another data set out there, maybe within your organization, maybe in the public domain, maybe with another larger organization. When you link those two data sets together, a person is identified. So that means if your data can sort of aid in that linkage, it's personal data. Just a very basic example, if you had a list of national insurance numbers, just on your own, those mean nothing to you. You can't pick anybody out from that list of NI numbers. But somewhere in your organization, maybe there's a finance team who has names which are associated with those national insurance numbers, or at the very least, the HMRC has additional information that allows those national insurance numbers to help identify somebody. So even though you think your list is not personal data, because you can link back, it's called triangulation, because you can triangulate the two data sets together to pick somebody out, the national insurance numbers you hold are personal data. That's kind of complex, so if during question time we want to go back to that, that's perfectly fine. The last thing I do want to say really briefly, this may be less of an issue for research purposes, but in your day-to-day normal work, any administrative work you do, this may be relevant. Personal data also includes any documented opinions you have about people. So what we always say at our institution is just make sure you use professional language when you are sending out emails or when you're recording anything. So if you are discussing colleagues or data subjects or other students that you may work with, just note anything you put down on the record, an opinion about them could become personal data. So it's important to be aware of that. Sensitive personal data is a separate category of personal data. It requires additional safeguards and precautions when handling and using. There are different requirements for processing this information in the first place. You'll get these slides later, so I'm not going to go through it. But as you can see, it's the sensitive information, the stuff you wouldn't necessarily disclose as readily as other bits about yourself. So what is processing? Very briefly, processing is anything that you are doing with information about people. You can kind of see here on this slide. Again, not going to go through it all, but it is literally anything that you're doing. So if you are going to be processing personal data, you need to meet a processing condition. Everything on this table, these are the processing conditions that you would have to basically select in order to use personal data. You need to make sure that whatever you're planning on doing, you have a legitimate reason for doing it. And as you can see, there's two separate sides to the table. There's one set of processing conditions for your general personal data. There's another set of processing conditions for sensitive personal data. If you are processing for research purposes, the fact that you're doing research doesn't necessarily matter. You can still select and use any one of these processing conditions that might be relevant to you. You just need to make sure that you can find a processing condition that works. So if you've got the explicit consent of an individual, if you've got consent forms for your research, that is your most straightforward processing condition, and that would allow you to use either personal or sensitive personal data. If maybe the information has already been made public by the individual, so to go back to Miriam was saying, social media data can be used for lots of different types of research. Potentially, if somebody has said something in social media, it's out there in the public domain, you can use that information. That would be your processing condition if it's sensitive personal data. Just for brevity's sake, I'm not going to go through every point on the table. Again, you'll have the slides later. But I will point out two, one on the table, fairly common processing condition for research, and that is legitimate interests of the data controller. That is almost a catch-all, but basically, if you have an argument that says the research that I'm undertaking is in the legitimate interests of my data controller, then that might be your reason for using personal data for your research, if you don't have direct consent for the individuals. For sensitive personal data, in addition to all of these conditions, there is a sort of addendum to the legislation. It's called the Data Protection Order 2000, and that provides additional instances where you can process sensitive personal data if you are not meeting any of the conditions here. So if your research is not for any of these particular purposes, you're not totally out of luck, because there is this DP 2000, and point 9 of that document says that if your processing is in the substantial public interest, so that's an argument you would have to make, and if it's necessary for research purposes, and if your processing doesn't directly impact or target any one particular individual, and it doesn't cause damage or distress, then you can process that sensitive personal data. So basically, if you're doing research and if you can argue that it is in the substantial public interest, then you can potentially process that sensitive personal data without meeting anything else on this table. So those, that Data Protection Order 2000 and the legitimate interests of the data controller, those might be your best options for processing conditions if you don't have direct consent. If you are using administrative data or data that's collected by another organization, which I'm assuming most of you guys will be doing, you still have to meet your own processing condition. But you will also want to know what the processing condition was for the organization that originally collected the data, because it always goes back to the idea of individuals need to have an expectation of what's going on with their data. So you need to look at what the original organization told the individuals when their info was collected. What was the original organization's condition for processing and collecting the data, and what were individuals told? This may require a discussion on your part, or maybe you're working with one of the data centers that Miriam talked about, and there'll be a discussion with them. What was the processing condition for the original organization? And this is something, their processing condition, your processing condition, those will be spelled out directly, ideally, in a data sharing agreement. So before I get into data sharing agreements specifically, I want to give you a little explanation of data controllers and data processors. These are basically two types of data handlers when it comes to personal data. The data controller is the person or organization who determines the purposes for which and the manner in which any personal data are or are to be processed. And as Miriam said, they're basically the owners of the data. They make all the decisions about what kind of data is to be collected, who's doing what with it, why are we collecting the data. The high-level decisions. The data processor is the person or organization, other than an employee of the data controller, who processes the data on behalf of the data controller. So the controller makes all the big high-level decisions, and the processor carries out the work. They maybe get to make decisions on how to carry out the work, but they don't get to decide what kind of work is undertaken. So when you're doing research, the data controller is usually the organization that has the principal investigator. You can have more than one data controller in a relationship. If you have two institutions who are processing personal data under a jointly agreed purpose, so they've worked together to decide exactly what they're doing and how they're doing it, then those would be considered joint data controllers. If you're working with an institution in collecting the personal data, but then you're each using the data for different purposes, then you might be what's called joint controllers in common. But the reason for sort of making the distinction between data controllers and data processors and the importance in hammering out that relationship is that there are different levels of responsibility when it comes to handling the personal data. The data controller is ultimately responsible for the personal data because they are that owner of the data. So anything that happens with the personal data, the controller is liable for. If there is a breach of any of those 8 principles, the data controller is on the hook, even if the processor was responsible for the breach. So it's really important to get that relationship figured out if you are working with other organizations, if you are sharing personal data. And the way that you sort of do hammer out in paper the relationship is with a data sharing agreement. That is a legal contract which lays out exactly how all parties are going to be handling the data, what the responsibilities are for the controller and the processor and everyone involved in the data handling and data usage. That would be, again, where you each sort of hammer out, nail down your processing conditions, how you're going to be dealing with the data, what you're going to be doing with it when you no longer need it. It is literally where it's the contract that says this is exactly what we're doing with the data, so that if something does go wrong, you can at least point back to the contract to say, well, we attempted to make adjustments for whatever the case may be, whatever the situation was. A data sharing agreement is something that the data controller is or should be responsible for. But if you are working with an institution where you are not necessarily the data controller, you are maybe the data processor, and the data controller has not come to you to arrange a data sharing agreement, you want to flag that up because you don't want to be in trouble if something goes wrong at any point. You want to make sure there's a data sharing agreement if you're working with another institution. And most likely a data sharing agreement will be created by your legal team or your data protection team, whatever the team may be at your institution. They'll be responsible. It's not something that you would handle on your own. So there is a section in the legislation that allows you or exempts you from certain principles if you are processing for research, historical, or statistical purposes. So it's Section 33 of the Data Protection Act. And that basically says that if you can show that you are processing personal data for research purposes and you're not using your processing or you're not using the personal data to support measures or decisions targeted at a particular individual, and if you're not going to cause substantial damage or distress, then you are potentially exempt from certain principles that we talked about earlier. So principle 2, that processing for reasons, for limited purposes. If you are exempt from this principle because you're processing for research purposes, then you can potentially use personal data for reasons other than that for which it was originally obtained, which is very helpful if you're using data that you want to maybe use later on down the line for additional research projects. You are potentially exempt from principle 5 as well, which means that you can hold personal data indefinitely. Again, very helpful if you've got a data set that is useful now, but maybe more useful in 10 years' time when technology is advanced or something like that. This exemption also allows you to, if your results are anonymized, claim exemption from the right of access to data in your data set. So that's Principle 6 or Section 7 of the legislation. Basically, that means if one of your data subjects comes to you and says, I want to see the information you hold on me, which would be their right in any other scenario, you can say, sorry, research exemption, basically. You do still need to ensure that you are meeting Principle 1, that the data is fairly and lawfully processed. So that means you have to have an identifiable processing condition, and you want to make sure that what you're doing isn't vastly different from what the data was originally collected from. And ideally, you want to let people know or at least raise awareness about your research. So maybe you're posting something in a newsletter or on your website. Again, just to give those people that sort of expectation and understanding of what's going on with their data. You do still have to adhere to the Principle 6 right to object. So if your results and your data are not anonymized, somebody can say, I don't want you to use my data in your project anymore, and you have to uphold that. And you are also still required to adhere to Principle 7, keeping your information secure, and Principle 8, making sure you're not transferring the data out with the EEA. But it's pretty useful, I guess, basically, is what I want to say. It's a handy exemption if you are doing research. I do want to also say that it doesn't allow you to use or process the data for research purposes. You do still have to identify that processing condition that you're going to use to process. But getting out of these principles is really helpful for research and for long-term research projects and for follow-up research. Very quickly, records management is really important for good research, basically, and for upholding the Data Protection Act. Records management is the main responsibility is the responsibility of the principal investigator. It's not their main responsibility, but it is something that they should focus on. So if you are the principal investigator, I don't know, maybe take note of this slide. Everything listed here, every bullet point is all part of exercising good records management and making sure that you have appropriate records related to your research project. If you do have good records management and you have handled your records appropriately, it really helps to ensure the transparency of your project and your research, to ensure the authenticity of whatever your data results are. It helps to uphold the privacy of your data subjects if you are working with people. It ensures credibility of your research project, because if anybody questions any of your results, you can point to all the records and activities that led to those results. And it's also a sign of good data sharing, because you will have documented all your data sharing agreements. So records management, it's not just basic admin filing tasks. It's really important to having a solid research project with robust research results. The last thing that I want to mention, so everything that I just sped through is about the Data Protection Act 1998. That's the current UK data protection legislation. There is a new data protection legislation coming into force in May of 2018. It's called the EU General Data Protection Regulation. Our current Data Protection Act is the result of an EU directive which said that every EU nation needs to have a broadly similar Data Protection Act. This regulation supersedes all those Data Protection Acts and the directive and says every EU nation needs to follow this new single set of rules. So the rules and the legislation will be changing slightly. This regulation also applies to organizations outside the EU that process personal data of EU citizens. So even though the UK is leaving the EU, we will still be, most organizations, large organizations in the EU, most universities and research institutions will still be dealing with EU citizen personal data, so they'll still have to follow this regulation. It's a bit sterner and more robust than our current Data Protection Act, and it is more focused on individuals' rights and their ability to exercise those rights, so it is something to consider when you are using the personal data of individuals. A really important point, particularly for research and your relationship with administrative data and maybe the data centers that you'll be working with, is that data processors are going to be responsible for their activities, so that changes the relationship between data controllers and data processors. Now, with this new regulation, whatever a processor does, they can be held liable for whatever their activities are, basically. So if they accidentally breach the law, they're in trouble now, not just the data controller. Data protection by design and default is a really big part of this regulation. So that means that whatever you're doing when you are designing your research projects, you need to be thinking about data protection. You need to be building the ideas of the principles and individuals' rights and how your research project is going to affect people's privacy into your system and your project right from the outset. There will be changes to personal data definitions. So online identifiers, IP addresses, cookie IDs, that kind of stuff, which you may end up working with, that'll be personal data, as will genetic and biometric data. That's going to be sensitive personal data. So if you are doing any research with that kind of thing, you need to start looking at it now as personal data. There are new and expanded rights for individuals. So people have the right to erasure, which is maybe one that will impact you guys. So if you have not anonymized your data, they can come in and say, erase all of my data from your systems. And they can say that to the whole organization, and you would have to, you'd have to follow that as well if you held data on that individual. And then lastly, mandatory breach notifications will now be required. So if something goes wrong with your project and the personal data you're using, if you lose a memory stick, if you have a database that gets hacked, if some system gets wiped, that could be a breach of the data protection regulation, and you will have to notify your data protection officer in your institution. So you'll need to be aware, basically, really on top of what you're doing with the personal data. So any further information, the best point of call for you guys, the first point of call would be your local data protection officer or team, or maybe data protection is handled by the legal team at your institution. They will have procedures and practices that they want you to follow in line with whatever your institution has decided in terms of data protection. If you have questions, get in touch with them. If you think you are doing data sharing, or if you know you are, if you know you're working with another organization or a research institution, get in touch with your data protection team. They can help you with a data sharing agreement. These are just a few other links for sort of additional general information. Again, you'll have the slides, so you can check those out later. And that's it. So thank you.